Good morning and welcome to the Osher at Dartmouth Summer Lecture Series. This is our fifth and penultimate session. I'm Pete Blyler and I'm today's session moderator. I'm also a member of the previous three sessions have been devoted to three of FDR's four freedoms that he stated in his 1941 speech. And today we will deal with the fourth one, freedom of speech and expression. You will note that we have a slight change in our format today, and I'll cover that in a couple of minutes. But the woman on your left is Nadine Strossen, and she is our featured speaker. The gentleman on your right is Mark Fischler, and again, I'll more formally introduce them in a few minutes. But first, the housekeeping, the usual housekeeping, which I'm sure you all got memorized by now. But turn off your cell phones and laptops. If you happen to have brought a laptop, which I don't know why you would have, turn that off too, please. Please note the exits down here in the front, right and left, and of course, exit to the rear where you came in. We will also have the usual break, approximately at 10 o'clock for a half an hour. And from 10:30 to 11:30, we'll have our question and answer period. And directly after this session ends at 11:30, at 11:45 to 12:15, there will be a post-session discussion in the Osher offices, 1 Court Street. Go out the doors, turn right, Court Street's that little street there, and halfway down the block is the entrance, and it's in classroom 3A in the Osher offices. I want to welcome all of you in the audience today in the recently also for you folks at the break, please write your questions down on the note cards you were given as you came in, and you can deposit them in this little bucket here or at the back of the auditorium. For those of you who are watching us virtually, please use the chat function to send in your questions as well. I now want to welcome besides the people in the audience, people joining us virtually from all across the country, or at least east of the Mississippi. We also have 9 of our sister Osher Institutes who are joining us regularly during the series. And you may or may not know this, but every Osher Institute of Lifelong Learning must be connected in some way with a college or university. So our sister Osher programs are at the University of Virginia, University of Rhode Island, University of Richmond, University of Michigan, University of Georgia, University of Connecticut, UMass Boston, Brandeis University outside of Boston, and Towson University in Maryland. And I want to give thanks, first of all, to Peter Paquette, our immediate past president, and this year's chair of the Summer Lecture Series. He really did double duty this past year. I also want to thank the rest of the members of the Summer Lecture Series Committee, our dinner hosts, and the people, volunteers today. And I want to thank the Lebanon Opera House for hosting us for the 3rd consecutive year, and the technical staff of Lebanon Opera House, as well as Junction Arts and Media for their work with the live streaming. Also want to thank our Osher staff. If we didn't have them, these wouldn't be possible, particularly Lisa King and Sarah Chamberlain. And then last but not least, our sponsors today. We have the platinum sponsor, the Jack and Dorothy Byrne Foundation. Our gold sponsors are Doyle and Lowman, Kendall at Hanover, and the Village at White River Junction. The platinum and gold sponsors sponsor all 6 sessions of our series. We also have 2 silver sponsors today. Silver sponsor sponsors 2 of the 6 sessions, and one of them is Legacy Counselor North, doing business as and formerly known as Caldwell Law, and the other is JMH Wealth Management, who is a new sponsor this year. Now let me get to formally introduce the 2 people on the stage. Nadine Strossen is a professor emerita at the New York School of Law and a senior fellow at the Foundation for Individual Rights and Expression, aka FIRE. She was the national president of the American Civil Liberties Union from 1991 to 2008, An internationally acclaimed free speech scholar and advocate, she is the host and project consultant for Free to Speak, which was a 3-hour documentary film series distributed on public television in 2023. Her most recent book about free speech was published just last month. It's entitled The War on Words, 10 Arguments Against Free Speech and Why They Fail. It was co-authored with FIRE's president, Greg Lukianoff. Consistent with Nadine's commitment to free speech and civil discourse, Nadine's presentations are always in the form of dialogues. For the first portion, her remarks will be presented through a dialogue with her longtime colleague and friend, Mark Fischler. After the break, she looks forward to engaging with the audience members responding to your questions. Mark Fischler is a professor of criminal justice at Plymouth State University, and he drove over from Plymouth this morning. Prior to joining the faculty, he practiced law for the New Hampshire Public Defender's Office, and he was awarded the Outstanding Teaching Award at his university in 2014, and has been nominated numerous times thereafter. He co-hosts a podcast called Integral Justice Warrior. Ladies and gentlemen, take it away.
Thank you so much, Pete. Nadine, such an honor to be with you, as always, and an honor to be with all of you today. Lifelong learners, that's what it's all about. So, I got a question for you right off the bat. You ready? So you've been writing and speaking about freedom of speech for a long time now, but you've made this your most important priority at the moment. Why?
Before I answer that question, Mark, I want to join you in thanking Pete and thanking the audience and thanking everybody connected with the Osher Institute, including Peter and Sarah and Lisa, who have been doing just an incredible job of organizing and planning. I feel so privileged to be here. And in addition to the wonderful name, Lifelong Learning Institute, I see that the theme of the Osher Institute is that you are learning because of the joy in learning. It doesn't have some specific goal orientation other than enlightenment and joy. So that is exactly why I have decided for at least the last 10 years to focus almost exclusively on freedom of speech, academic freedom, open inquiry, viewpoint diversity, civil discourse, a whole interrelated cluster of issues that are really my passion. Not because I no longer care about the full spectrum of civil liberties that I worked on so hard as ACLU president. I still am very committed to that agenda of defending and promoting all fundamental freedoms for all people. But I have seen in the last decade or so an increasing erosion of classical liberalism, Enlightenment values, the ones that I recited relating to freedom of speech, with attacks coming from both ends of the political spectrum. And based on my long experience now, as well as from my study of human rights and civil liberties around the world, I am absolutely convinced that without robust freedom of speech and the associated rights, none of the other rights will be secure. So in my waning days on this planet, my highest priority is to focus on that essential underpinning, not only for all individual liberty, but really for anything, right? Anything that we want to advocate on any policy issue, anything we want to communicate to a friend or a loved one depends on freedom of speech.
Okay. So give us your elevator speech then for freedom of speech and why it's so essential if you feel that way.
How high is the elevator? That just occurred to me. But, you know, in all seriousness, freedom of speech is and I'm going to paraphrase Supreme Court Justice Louis Brandeis, who I think actually said it best, has both intrinsic and instrumental values. Intrinsic, who we are, how we explore our identity, our sense of self, what we believe, could not take place without freedom of speech. The Supreme Court also said more recently that freedom of thought is the beginning of all human freedom, and freedom of speech is the beginning of freedom of thought. So that's the intrinsic value, self-expression. Beyond that, it is essential for every human relationship, which depends on communication, and it is essential for every societal and public purpose, especially in a democratic republic such as ours, where we, the people, to quote the opening words of the Constitution, wield sovereign power. How can we do that effectively unless we have the most robust freedom to debate, discuss, question, and criticize those who are seeking to represent us as officials, and without the ability to critique their policies? The Supreme Court, again, put it very well when it said, speech about issues of public policy is more than a matter of individual self-expression. It is the essence of self-government. I guess that got us to the top of the World Trade Center.
Pretty high, pretty high. So there's an argument that First Amendment law is too rigid and absolute. And how do you feel about that? How do you answer that? Or do you agree with that?
This is one of the recurrent arguments that my colleague Greg and I answered in our new book, 10 Arguments Against Free Speech and Why They Fail. It's a very serious argument, but it is inaccurate. I reject it. So please make note of this if you have not already. When you hear people criticizing freedom of speech under the First Amendment, I guarantee that they will use the word absolutist, exceptionalist, that American freedom of speech under the First Amendment is ridiculously extremist, absolutist, never permitting any limits at all, completely deviating from the rest of the world. And oh, you free speech champions, including the ones who sit on the Supreme Court, you don't even recognize that speech can do any harm. No, 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 and no. Those are caricatures and distortions about free speech. Having steeped myself in the hundreds of Supreme Court decisions that make up the law under the First Amendment. The First Amendment free speech clause is very terse, so as I'm sure you all know, Congress shall make no law abridging the freedom of speech. Every single word in that phrase has been subject to a lot of debate and interpretation with hundreds of Supreme Court decisions. And on one level, it's very complex, but the more I studied it, the more I realized that this body of law sorts itself down into two fundamental common sense principles. Number one, the speech that is the most dangerous may be restricted, consistent with the First Amendment. Number two, the speech restrictions that are the most dangerous may not be imposed. That would violate the First Amendment. And if I can elaborate, there are two legal terms that we use to capture those core common sense concepts. Let me start with the one that the Supreme Court has called the bedrock principle of freedom of speech. It's usually called viewpoint neutrality or content neutrality. And that means that government must remain neutral with respect to the viewpoint or the content of the speech, its idea, its message. The fact that government may dislike or disagree with that idea, or the fact that the majority of the community may dislike, even hate that idea, even find it hateful, that is never a justification in our democratic republic cherishing individual liberty. That lack of popularity is never a rationale for suppressing the speech. If you don't like it, ignore it, answer it back, refute it, debate it, etc., but don't call on government to make that choice about which ideas are officially approved, which are not officially approved. So any speech regulation that is not viewpoint neutral, that is viewpoint discriminatory, viewpoint based, is unconstitutional. That is the most dangerous form of speech restriction, because it allows government not only to deprive us individuals of the freedom to decide what we want to say, and what we want to listen to or believe and not listen to or not believe. That's our choice, not the government's choice. But by government, if government starts picking and choosing which ideas are in or out based on viewpoint, that allows government to manipulate the public debate that is the essential undergirding of democracy. So that's very dangerous for democracy as well as individual liberty. Correspondingly, the name that's used for the other principle, where the most dangerous speech may indeed be restricted, it's often called the emergency principle, picking up on an idea that was first voiced by the great early 20th century Justice Louis Brandeis. Speech may not be restricted, considered solely based on its content, as I've just explained. But when you look at the speech in its overall context, taking into account not only its viewpoint, but all the facts and circumstances, if in particular circumstances the speech directly causes or imminently threatens certain specific serious harms, then it can and should be suppressed. And the Supreme Court has recognized several categories of these contextually based emergency situations in which government may restrict speech, and some of them will sound familiar to you. Targeted harassment or bullying, an individual threat that intends to put somebody in fear that they're going to be subject to an attack. Intentional incitement of imminent violence that's likely to happen imminently.
So the Constitution isn't really so rigid and absolute in relation to the First Amendment. So free speech has become a controversial topic for an unusual group of people who you would think would be the defenders, professors, students, librarians. What do you have to say about that? Why is that happening? And is obviously, I'm guessing you think that's not wise. And can you dig into that for us?
Yeah, Mark, as I've said in response to the first of your excellent questions, about 10 years ago, I really saw a crisis where, free speech has always been under attack, along with all civil liberties throughout my lifetime, but the crisis that was new or, newly enhanced based on my experience was increasing attacks coming from segments of our society and institutions that traditionally had been particularly supportive of free speech, starting with academia. I don't know how many of you, I know we're affiliated with Dartmouth, how many of you follow the issues on campus, but they're actually going back to the 1980s when we saw a movement for hate speech codes on college campuses, at least from that period on. Academia has really abandoned longtime traditional support for free speech to a large extent, which is exactly why an organization such as FIRE, whose acronym for 25 years stood for the Foundation for Individual Rights and Education, FIRE was founded specifically to address that crisis, and we've seen many other newer organizations along those lines in the more recent past. Journalism. I have debated the dean of the Columbia School of Journalism, which is considered one of the best. We debated each other at the Aspen Ideas Festival, and it was a debate about free speech. Well, you know who was in favor of free speech, right? So you can guess who was on the other side. And he was at least the second dean of the Columbia Journalism School in a row to argue that our traditional support for free speech is misguided. We've seen it in the publishing industry, the entertainment industry, even among librarians. I have many librarian friends who tell me that the younger librarians who are graduating no longer have the traditional commitment to putting on their shelves books that are controversial, whose authors are controversial, whose ideas might be deemed upsetting or traumatizing and so forth. So that is a good, that last example, Mark, is a good segue to the why. I'm very much an optimist. I always see the glass half full. Wow, it's even more than half full now. And I think that the impetus from the left, and believe me, there are a lot of censorial pressures from the right, the ones that I've been describing are institutions that are part of the left end of the political spectrum. The impetus for speech repression comes, I think, from a very positive place, and that is a deeper concern than I grew up with in a much earlier generation, a deeper concern for equality, for inclusivity, for individual dignity, all of the values that are summed up in a phrase that unfortunately has been maligned, DEI, diversity, equity, and inclusion. Those are such positive values and completely consistent with the equal protection guarantee in the Constitution. So the impulse, for example, for hate speech codes in the 1980s, I think is really what started this. And it was a notion, not irrational, that it's one thing to lower the barriers that have literally excluded or marginalized whole segments of our population based on race, ethnicity, gender, and so forth. And that's a start, but then to subject these people to ideas and words and expressions that are insulting or degrading or even hateful or discriminatory really undermines their actual meaningful equality. And when that argument was made in the late 1980s, the ACLU, of which I was just becoming the national president, had very serious debates. We traditionally had opposed government restrictions on hate speech and other controversial speech based solely on viewpoint. Some people, how many people have heard of the Skokie case? Oh, no, yeah, okay, I see quite a few hands going up. So often I just say Skokie and people know that that kind of summarizes the viewpoint neutrality principle in a very dramatic fashion. In the late 1970s, the ACLU, which has been at the forefront of fighting against racial and religious and other kinds of discrimination, came to the defense of the free speech rights of a group of neo-Nazis who wanted to peacefully demonstrate in Skokie, Illinois, a town near Chicago that at the time not only had a large Jewish population, but at the time, many of them were Holocaust survivors. It was an easy case in the courts of law, right? Ugly viewpoint does not justify government censorship, but it was a very unpopular decision in the courts of public opinion. Even many ACLU members drew the line, and we lost 15% of our members. So it's a hard principle to swallow. But that at the time of the Skokie case, the major argument that was made in favor of censoring the Nazis was a concern that their demonstration could lead to violence. So another decade goes by, and the new argument is being made by professors that if we truly want equality and inclusivity and belonging on campus, that is a different and more persuasive justification for censoring hate speech. So we took that very seriously, Mark. We had a committee that studied it. We had massive debates. And it ended up being one of the very few votes I can remember during my entire 18 years as National ACLU president, where there was actually a unanimous vote of the board to reaffirm our traditional position opposing censorship of hate speech just based on the viewpoint. And I really want to underscore that that conclusion was not because we valued free speech more than we valued equality and dignity and the countervailing asserted interests, but rather because of the conclusion, which I continue to adhere to based on continuing review of the evidence, that no matter how well intended, censoring speech is at best ineffective and at worst counterproductive for actually advancing meaningful equality. All we have to do is look at what's happening in the UK and other Anglophone countries and European countries, which do have very strictly written, strictly enforced anti-hate speech laws, and they have surging levels of not only hateful speech and attitudes, but also discriminatory violence against Jews, against refugees, against Muslims. And they have turned these laws into weapons that paradoxically but predictably are disproportionately used to silence the voices of the very members of the minority groups who were hoped to be protected. So to make a long answer short, I agree with what I think is the very laudable impetus for cutting back on speech, to promote greater equality among a broader range of groups and individuals in our society. But censorship is not the way to promote effectively that very important goal.
So, speaking of Nazis, you're the daughter of a Holocaust survivor, and you're taking a position of defending the rights of these folks to speak and share racist, hurtful, painful statements that could cause potential damage down the road to people, potentially. How do you reconcile that? And then further, if you could help the audience and myself understand a little bit more deeply about how it's said that, well, the Constitution protects hate speech, but there are those that argue that hate speech isn't constitutional, it's not protected speech. So can you make sense of that for us and maybe give us your personal understanding of why you support these folks to say what they say? So you mentioned my beloved father, and you also had a wonderful father, so it's like I want to salute, who also supported free speech, including mine, bringing me to your campus. You brought back a memory which I hadn't thought about for a while, Mark. I'm going to date myself. I have a birthday coming up, and when I was
Well, I won't even go back that far, but I had just become ACLU president, and I was invited out to San Diego, which had had a recent spate of episodes of anti-Semitic and anti-Black and other hate speech. Synagogues were defaced, and there were some other disturbing, racist, discriminatory graffiti. So I was invited out by the local ACLU and Anti-Defamation League and a coalition of civic organizations to explain why the ACLU defends freedom. By the way, if it's vandalism, that is a crime. No matter what your message is, it can be loving or hateful, it's still a crime. But why we defend the right simply to voice a discriminatory or hateful idea. My dear father had retired in San Diego, and he came to hear my talk, and he had not heard me give a public speech since my high school graduation. That's where I started out, which was 1968, and I gave an impassioned anti-Vietnam War speech. Some of you are contemporaries of mine, so I'll tell you, I graduated on June 6, 1968, which was the day that Robert Kennedy was assassinated. And I'm still getting chills when I think about that. So I threw away my planned speech and was quite eloquent about the violence and in Vietnam and the violence in our country. My father did not like that speech either. We still remained friends, and he came to hear me talk in San Diego. And he came up to me afterwards and he said, you know, I listened very carefully, and you were very persuasive in explaining the First Amendment and that the ACLU is correctly interpreting the First Amendment following Supreme Court decisions when it defends freedom of speech for Nazis. Thank you for making it clear to me that the problem is the First Amendment. But then, you know, we got to talking, and he totally supported what I was doing. And the truth of the matter is, Mark, to bring this really close to home, many people engage in what a lot of us in the free speech trenches call the Weimar fallacy, referring to the Weimar Republic in Germany in 1918 to 1933, during which Hitler rose to power. And the argument is, oh, if only they had had hate speech laws and had restricted Hitler and the other Nazis from speaking, that could have prevented Hitler rising to power, and that could have prevented the Holocaust. Well, sign me up. You know, if I were convinced that would have worked, I would be enthusiastically in favor of it. But the historical record is very much to the contrary. The Weimar Republic did have very strict anti-hate speech laws, which are very similar to the strict ones that Germany is still enforcing. They were very strictly enforced. There was an organization quite similar to the Anti-Defamation League with chapters around Germany that would actually bring civil lawsuits to enforce the hate speech laws when they were used against, when hateful anti-Semitic speech was being aired. And they also put pressure on local prosecutors to bring prosecutions. And there were countless prosecutions against top Nazi advocates. The publisher of Julius Streicher, the publisher of the, infamous anti-Semitic Der Stürmer, was repeatedly convicted. Hitler himself was barred from public speaking for 5 years in a particular important region in Germany. So the problem was not the absence of laws suppressing hateful views. The problem was the absence of enforcement of laws against actual hateful violence, including murder and assassinations against Jews, against socialists, against communists, against other political opponents. So, again, we can share the goal of countering anti-Semitism and any other form of hatred, but disagree strongly about what is an effective means. If I can say one other point about that, Mark, because going back to the other question about American exceptionalism, I wrote a book called About Hate Speech in 2018, and the title of the book really summarizes, oh, that's even shorter than an elevator pitch. The title of the book is Hate, Why We Should Resist It with Free Speech, Not Censorship. And in that book, as you know, Mark, as you kindly read it, I quote dozens of human rights activists, racial justice activists, advocates for equality and inclusivity from countries all over the world who oppose censoring hate speech. And they do so not because that censorship would violate the laws in their own country. No, the laws of their own country allow that censorship. But they have come to experience through how these laws operate, what they do accomplish and what they don't accomplish, that they are doing more harm than good to the cause of countering hatred. If I can just give one terse quote that comes from a regional group in Europe, a European Commission Against Racism and Intolerance, ICRI. They did a report a few years ago about the enforcement of hate speech laws in Europe, and their conclusion was counter speech, this is an exact quote, counter speech is much more likely to be effective than censorship. And what is counter speech? It's what all of you are engaged in. It's education, information, knowledge, persuasion, discourse, dialogue, hate, discrimination. These are attitudes. You don't change attitudes by putting someone in prison. You also don't change attitudes, as is more likely to happen in this country, through shaming and shunning and cancellation. You change attitudes through the laborious but ultimately only promising path of more speech, education.
It's interesting too, because we've talked about this in the past, that some groups that are really advocates for the poor, the downtrodden, have been classified as hate speech, like Black Lives Matter movement, things like that. And so it's very tricky, you've taught me, when that goes down that way. Do you want to talk about that at all?
Yeah, and I'll go back even earlier. You're so young, Mark, that I don't mean to sound patronizing, but I know you've studied history. But I continue to be shocked because it's so easy to forget that when Martin Luther King, who was also assassinated in my senior year of high school, at the time that he was assassinated, he was deeply unpopular all over this country. And to say he was hated, sadly, is not an understatement, an overstatement. He had something like almost a 70% disapproval rating nationwide, and people really feared his crusade, not only for meaningful equality, but at that point he was even moving beyond racial equality to concerns about income inequality, and he was against the war in Vietnam. All of these were extremely controversial positions, as we know, led to the FBI surveilling him and putting him on lists of national security threats. But what we now see, I think widely, the conventional wisdom is this is pro-loving speech, right? And it's consistent with the highest ideals that the United States stands for. It was seen exactly the opposite, as subversive and threatening to national unity and national security. So I think the bottom line is hate is an emotion. It is an inherently subjective concept. What one person considers hateful and dangerous, somebody else may well consider loving and positive. And I want to give what to me was the most startling example, because I'd love to tell a story about myself. You know, all of us have blinders, and I think I don't have blinders about having blinders, which is a start. But this was, to me, one of the most kind of embarrassing but enlightening revelations. I used to frequently give as an example of hateful expression the Westboro Baptist Church. And I'm sure you've all heard of it, at least some of its activities. Its website logo says it all, and trigger warning, it's quite a hateful expression. www.godhatesfags.org. Well, the Westboro Baptist Church used hateful expression not only against LGBTQ people, but against members of the military, against Catholics, against Jews, against blacks, basically anybody who wasn't a member of their church. I think they may have come most to public attention while we were fighting the Iraq and Afghanistan wars. They would picket outside funerals of slain members of the military, you know, reeling with all of these hateful messages. So Megan Phelps Roper was somebody who, it was a family-oriented church. She was born into the family, grew up in the church as a little kid, was picketing these funerals with these hateful signs. And to make a long story short, not through criminal punishment, not through shaming, shunning, and ostracizing, but through more speech and dialogue, she weaned herself away from this ideology that she had completely grown up in, and she did it. Ironically, since she was young, the family recruited her to go out onto what was then new Twitter and other social media to recruit younger people to their church, and instead, she was weaned away by engaging in a really extensive dialogue with an Orthodox Jewish rabbi in Jerusalem. You have to, you know, people are so down on the bad sides of social media and the internet. And he engaged in a process of just discussing particular Bible verses with her. And not in a didactic way, but just asking questions that forced her to rethink the interpretation that had been accepted as true from her family's perspective. Anyway, she then wrote a wonderful book. She's given TED Talks. I couldn't recommend them more highly. And her book was called Unfollowing: Loving and Leaving the Westboro Baptist Church, you know, real case in point of counter speech working really well. She was on NPR's Fresh Air with Terry Gross, and Terry Gross said to her something like, in passing, so Megan, we know that you hate LGBTQ people, and that was going to be the prelude for a question. And I often said the same thing. This is the paradigmatic hateful group. And Megan interrupted Terry Gross and said, no, we don't hate gay people. She said, listen to what our motto is. It's God hates fags. We're the only people who truly love them because we don't want God to condemn their everlasting souls to torment in hell. We're trying to rescue them from that. And I thought, wow, you know, I still don't accept that philosophy, needless to say, but I understood that it's not necessarily accurate to say that that is reflecting a hateful view. So that's a rather, you know, elaborate example, but I think we have to be humble about putting those binary labels on any idea, much less any word.
Yeah, so that reminds me of the principle of not making assumptions, right? You just don't know. And the dialectical process allows us the opportunity to get to know and unearth a deeper truth.
Humility, intellectual humility is essential for learning and living.
Yeah. So let me...
If I may say so, you know,
Yeah.
in this book that I co-wrote with Greg, and I've known him for so many years, but and read so much of his writing, but I learned a lot from each of us provided our own answers to the same set of questions. And even though we have the exact same orientation and philosophy, it was quite interesting to me to see how we approached each question somewhat differently. And one of the points that Greg made, just in passing, but it really gets to this profound point about intellectual humility and openness. Greg referred to the Enlightenment, and he had a parenthesis in which he said, which was really a discovery of how little we know. That's exactly right. To be enlightened is to be aware of your ignorance.
Right. And you could go back even further on that to Socrates, right? And why he was the wisest in Athens, because he knew he did not know. And so that's great. If I can move us towards disinformation. So the 2020 election, we all know there's tremendous amount of disinformation. COVID, 2020, same time, tremendous amount of disinformation. And that disinformation could theoretically not even just theoretically, was harmful to people's health. The disinformation regarding the election was harmful, as we're seeing, to our democracy. So where does the First Amendment come down in relation to disinformation? And further, are the lines drawn in the right place because of the potential harms or harms that have happened because of 2020 and COVID and the election?
So I disagree with some of your factual premises, which you may have been putting out there as devil's advocate. But before I get to those, and let me just say, because the term disinformation or misinformation, I'm using scare quotes to underscore the lack of precision. To the contrary, the inherent subjectivity of those terms, which makes them completely analogous to hate speech. That is the essential problem, is that we're talking about matters of subjective judgment, and therefore we do want to give government as little power as possible to make those subjective judgments and to take the power to make them away from us as individuals. But let me start with the legal principle, and then I'll circle back to that factual point. Consistent with the emergency standard, the Supreme Court wisely has recognized several categories of false speech, lies, misleading speech, right, that do satisfy context-based standards of directly causing demonstrable, tangible harm, and therefore they can and should be punished. And these will sound familiar to you. One really good example is perjury. If you lie in a court of law or legal proceeding, you are undermining, violating due process, interfering with justice, fair trial, and the rule of law. That's punishable. Fraud. You intentionally make a statement to somebody intending them to rely on that statement to their detriment. They do rely on it. You've defrauded them. They've lost some demonstrable good, usually financial. Let me give you one final example, defamation. You intentionally lie about somebody, you damage their reputation in a way that has a demonstrable adverse impact, again, usually financially, professionally, and so forth. But when we get beyond those, specifically contextually defined concepts of punishable false information, and we use this slippery term, disinformation, it has the same problem that you have with hate speech. It gives the government too much latitude that predictably is going to be enforced in accordance with that government's policy preferences. So you talk about COVID-related disinformation. different people had different views, including different scientists had different views about very important public policy matters and health-related matters that would be relevant to figuring out the cause and the cure, including the so-called lab leak theory, which was suppressed vehemently by the Biden administration and by social media companies under pressure from the Biden administration. And subsequently, we've all learned that the leading US agencies in both the health field and the national security field have concluded that the lab leak theory was probably correct. We also saw different views and shifting views, even on the part of the very same officials, about masking, about distancing, about the opening of schools, and so forth. I mean, ultimately, the scientific method, which is the same as the Socratic method, is especially important when we're dealing with a public health emergency. Let all of the information and disinformation and hypotheses and theories out there so that everybody can maximally debate them and pick out which ones are more persuasive. What happened during COVID was many governments did pass anti-COVID disinformation-oriented laws, and every single one of them was enforced against any criticism or dissent from official government policy. We had one example in the United States. Puerto Rico passed COVID disinformation law. The ACLU immediately brought a lawsuit against it. We represented two very respected investigative journalists who said, look, you know, in a fast-breaking situation, you do the best that you can, but you're inevitably going to make mistakes, and you don't want to self-censor. You want to get as much information out there as possible to guide the public, to guide the policymakers, to guide the scientists. Sure enough, that disinformation law was enforced against journalists who did air criticism of government policy, criticism which turned out to later be warranted. The judge in our case actually said, especially when you're dealing with really important subjects such as public health, such as elections, that is when it is especially important to have the most robust debates. And far from undermining public health and undermining democracy, free speech is the safest way to protect both public health and democracy.
Do you want to talk at all about the election and as part of that in terms of disinformation, or you want me to move on?
Yeah, so again, there's so many factual disputes about election disinformation, and to the best of my knowledge, Mark, and I've read a lot about it, including massive studies that were published in the Columbia Journalism Review, the consensus is that the amount of election-related disinformation was very small, that it was propagated by a very small hardcore of people who were speaking only to another small hardcore of people and had no demonstrable impact on the outcome of the election. Now, let me give you an example of, in fact, I just heard something about it yet again today on New Hampshire Public Radio, which I was enjoying listening to. Let me give you an example of election-related false speech, lies, I'll use the more concrete term, that could be punished in the context, consistent with the concept of fraud that I mentioned earlier. If you make a statement that you know is false, intending somebody to rely on it, and they rely on it to their detriment, that can and should be punished. And in the electoral context, and I think there were some examples of this, if you say, oh, you can cast your vote via email, and you know that somebody's going to rely on it, and they do it, and they forfeit their vote. Or this is your polling place when it's not your polling place. So something that has a demonstrable adverse impact on casting your vote should be punishable as fraud.
Okay. So, cancel culture. What can you help elaborate and help us understand what that is? And just for a counter argument, isn't punishing someone, canceling someone out, a form of free speech itself? And so what's so wrong with that?
Let me start with the last part of your question. The fact that you have the right to say something doesn't mean that it is right to say something. And I think all of us, especially those of us who oppose government censorship and want maximum individual freedom of choice about what we say, have to be very cognizant of using that precious right carefully and responsibly. It's what, we professors and we educators, we try to communicate effectively in a way that will be clear and compelling to our students. As a lawyer, as an advocate, I choose my words very carefully in the hope of being persuasive. As a member of a diverse, wonderfully pluralistic society, who believes profoundly in equality and inclusivity and belonging, I want to use my speech respectfully, to be maximally appreciative of the dignity and diversity of all of my fellow members of the community. So what I'm talking about is encouraging certain uses of our free speech and discouraging others. But I would not support government-enforced rules along these lines. So I can encourage my students in class to use appropriate language that would be appropriate in a court of law. I'm training them to be lawyers. I can encourage everybody I know to please be respectful in your language and civil in your discourse, even toward people you dislike, even with respect to ideas you disfavor. But I would absolutely oppose any government mandate or any government proscription. So that's the difficult aspect of cancel culture. Especially, for me, the harder part, Mark, is even beyond the hard question you asked me. Think of my book about hate speech, why we should resist it with speech, not censorship. And I've talked a lot about counter speech. Counter speech is ultimately a form of cancel culture. The purpose of it is to try to dissuade somebody from having certain ideas and engaging in certain expression. But it's a matter of tactics and a matter of degree that I believe very strongly that we should use persuasion and conversation, even with what we perceive or perhaps misperceived to be confirmed hate mongers. And there are so many, many examples of where that strategy has worked. There are many organizations of former leaders of white supremacist and other hateful, discriminatory organizations that are now devoting their entire lives to helping others to redeem themselves. And they do this through reaching out in a very empathetic way, not condemning, not even lecturing, but through a very patient process of asking questions. So canceling, one expert that I really, really respect, and I think I gave some recommendations to Lisa King for resources, and I suggested some TED Talks. One is by a wonderful woman named Loretta Ross. She's a lawyer, she has other social science backgrounds, and she had been a lifelong crusader for women's rights and against domestic violence. And she goes into domestic violence and rape. She goes into prisons and engages with convicted rapists to help them acknowledge and surmount their misogyny and their negative attitudes toward women. Another example who's also given great TED Talks, oh, by the way, Megan Phelps-Roper has also given great TED Talks. This is an easy, pleasant way to get information. Daryl Davis, a black rock musician who has converted something like 200 members of the KKK who have donated. He's got a whole collection of KKK robes that they've donated to him.
So in a way, you're advocating a form of restoration as opposed to canceling.
Restorative justice.
Yeah. So we've got a few minutes left. I want to ask you about the Trump administration and its second term. President Trump talked about how he was going to protect free speech and not censorship, go the other way. But critics have said that he's done the opposite, from litigators to judges, other folks in the law. What say you on the subject? How has he doing on the free speech front?
First of all, if anybody tells you I'm against censorship and I'm for free speech, it's not worth very much. I have spent decades debating every single advocate of every major censorial, I should say every major advocate of every major censorial initiative, and every single one of them says, I am not in favor of censorship. This isn't censorship. This is protecting national security. This is protecting children. This is protecting public safety. So the language only gets you so far. And my experience also is this, Mark, which is why the ACLU never endorses or opposes any candidate or official per se. We just simply criticize or praise every single one of them on an issue-by-issue basis, because without exception, everybody is good on some issues and bad on some issues. So let's start with the positive. Trump did oppose the kind of jawboning and government pressuring of social media companies that was taking place under the Biden administration. Maybe not perfectly, but that was something that he put some emphasis on. That said, while condemning the kind of woke cancel culture that he saw as being predominant on campus, Trump has substituted it with a different type of orthodoxy on campus, namely one that is purging not only the concept of DEI, but any reference to DEI. Indeed, there have been lists of words that have to be purged from course catalogs, from curricular, from library materials. And beyond all of the specific government measures that have used the traditional tools of regulation and new statutes, new enforcement of existing statutes, the Trump administration is doing something that I think is unprecedented, certainly in my lifetime, and according to historians, even beyond that. And that is not only eroding the famed and essential checks and balances within the government. And the Congress gets a lot of the blame too, because Congress has been supine. We're not seeing the check that Congress should provide on the executive branch. The judges are doing quite well, but who knows how long that will last, given Trump's extraordinary attacks not only on individual judges and the judiciary, but on the legal profession, where you have lawyers and law firms within the government and in the private sector who are being intimidated and threatened and retaliated against for representing clients or causes or making arguments that Donald Trump disapproves of. We cannot, the Constitution is marvelous. The First Amendment, free speech clause is marvelous. None of it is self-executing. None of it is self-enforcing. For the vast majority of the history of the First Amendment, which went into force in 1791, it was a dead letter. That's why Martin Luther King wrote his famous letter from a Birmingham jail, and I could give countless other examples. We only started to have meaningful free speech when we had individuals who were knowledgeable about their free speech rights, who had the courage to stand up and exercise them, and who had legal resources in organizations such as the ACLU and the NAACP and FIRE to actually go to court to get a judge to turn the abstract words and paper promises, as James Madison called them, into real rights for real people. So I'm very concerned about the attack on the legal profession and the other institutions in civil society that have also traditionally provided checks and balances, including the journalism profession.
I think we've run out of time for this part, and I just want to say, you said something earlier about the Enlightenment, and this has been enlightening. I think we've all gained a lot. I've learned a lot as usual, so thank you so much, Nadine.
Thank you so much, Mark.
Okay, we'll be taking our 30-minute break, and it's 10:05. Be back here at 10:35 for the Q&A, and you can bring your questions up here, or in the bucket back there, or on the chat function. Thank you. Okay, right. Right. What? Okay. Okay, welcome back. Before I ask the first question, I just want to mention that as Nadine and I were driving over this morning from the Hanover Inn, I found out that this is actually her second time here as a presenter. And I said, how long ago was it? And I said, was David Bisno, then had, as you all know, he was started in 1997. And she said, well, he was a doctor. I said, okay, David, if you're here, wave your hands. Okay, the first question is, what First Amendment standards govern removals of books from public school libraries? And what is the motivation?
Okay. Well, first of all, Pete gave me the opportunity to look through the questions that were coming in person and online, and they were fantastic questions. Apologies in advance that we're not going to have time to answer all of them, but some of them were in clusters, and there were several that were about book banning, which is, of course, a topic of major concern all over the country. The United States Supreme Court has not provided much guidance on this issue. The only guidance is a case that goes way back to 1982. It was an ACLU case, and the court considered the issue so difficult that it did not even issue a majority opinion. It was what was called a plurality opinion, and there was a dissent. Because basically, you don't have a right to have a public library acquire a particular book in the first place. And so the court was also not so clear about what are the limits, if any, on the removal of a book from a public library. And the best way I can summarize what is an ambiguous Supreme Court decision is to say that the court, and I think it was correct in this respect, the court said whether it is constitutional or not to remove a book once it is in the library will depend upon what the purpose for the removal is. So if the purpose is something that is consistent with the professional, expert, educational type judgment of librarians or others who are tasked with these decisions, for example, that the book is, falling into disrepair, or the book has not been checked out in a long time, there's not so much public interest in it, or in a school library that the educators decide that the book is not educationally appropriate or age suitable. Those are permissible purposes. You may notice that this ties back to that core bedrock viewpoint neutrality principles. If the reasons for removing the books are viewpoint neutral, not because of disapproval of the ideas, not because of disapproval of the authors, that is okay. If, conversely, the purpose of the removal is specifically and primarily, predominantly, because of disapproval of the viewpoint or discrimination against the authors, that would be unconstitutional. And the examples that the court gave, so in that particular case, it didn't reach an ultimate resolution on something like a dozen books that had been removed because it simply remanded the case to the lower court to examine the facts to find out what the purposes actually were. And the examples it gave of a viewpoint or speaker author discriminatory purpose that would clearly be unconstitutional. They're very extreme examples. Number one was if the library decided to remove all books that were written by Democrats or all books that were written by black people or by women were removed. I mean, that's a far-fetched example. That would be unconstitutional. What we have seen in many parts of the country is, in fact, removals that seem to be based, I have not done factual examination, but based on the reports that I've read from the American Library Association, PEN America, which has done a lot of work in this area, that many books do seem to be targeted because of their themes and the identity of the authors and identity of characters. So there's been a very large number of books by or about LGBTQ individuals and a very large number of books about racial minorities or about racial minorities that have been targeted. That's very concerning. If I can just give one other complexity here. We had a recent decision by the United States Supreme Court at the end of June, some of you may have read about it, from Montgomery County near Washington, D.C., the most diverse county racially, ethnically, religiously in the most diverse school district in the whole country, where books were removed allegedly because of age inappropriateness of certain sexual gender themes. But there was a real factual dispute there as to whether age appropriateness was really the basis for the removal decision, or rather whether it was disapproval of ideas about trans people in particular.
During the first part, you talked about the rise of Hitler in Germany, and this person says, totally disagree. I lived in Germany when Nazi propaganda was promulgated through free speech.
So I'm so happy that I get somebody who completely disagrees with me and who I actually agree with what the writer said, that Hitler did have a lot of free speech, but not complete free speech. He was banned, I'm pretty sure it was in the state of Bavaria. We actually mentioned this in our book, but I can't remember. And he actually distributed posters or the Nazi Party distributed posters of Hitler with a gag across his face, and it lists whatever the population of Germany was at the time, and it says, you know, all these people have free speech in Germany except for one, and that one is him. Obviously, that ban only was in part of Germany and only lasted for a limited period, but it did take place. Now, I said that I want to add something beyond the points that I made in the opening presentation. So here's what I want to add, and it's an opportunity to make a plug for a really important book. I mentioned the infamous Skokie, or famous Skokie case, depending on your perspective, where the ACLU came to the defense of a group of neo-Nazis in Skokie, Illinois in 1977. The national executive director of the ACLU at that time was a wonderful man named Aryeh Neyer, who went on to become the founding executive director of Human Rights Watch, the founding executive director of the Open Society Foundation, a giant worldwide in the human rights movement, as well as the civil liberties movement. Aryeh himself was a Holocaust survivor. He was born in Germany in 1933. His entire extended family was slaughtered by the Nazis. Ultimately, after a huge amount of suffering, he and his immediate family escaped, became a refugee to the United States, ultimately became executive director of the ACLU. And you can imagine how, given his background, he was constantly asked how, with that background, he could possibly defend free speech for Nazis. And I won't try to paraphrase it, but I will commend to your attention, it's on the reading list that I suggested. He wrote an amazing book right after the case, it was published right after the case was ended, called Defending My Enemy, American Nazis and the Risks of Freedom. And it is such a powerful, personal and principled and philosophical and pragmatic defense of free speech and opposition to censorship that is rooted in his experience in Nazi Germany, as well as his experience in this country. I was constantly citing it in all of my public presentations, and it went out of print. So to make a long story short, I suggested to a couple of publishers, and with RA's participation and support by both FIRE and the ACLU, the book is being republished. It's going to be officially republished next month. We're having a launch event at the University of Chicago, and REA very graciously invited me to write an afterword in which I talked about how these lessons continue to be so resonant in debates today. He wrote a new chapter in which he reaffirmed his prior position and brings it up to date with the last 50 years. And then one other point, we recruited to write a new introduction, or new foreword, Eleanor Holmes Norton, the longtime representative of the District of Columbia in Congress, African-American woman, civil rights activist and leader. At the time of the Skokie case, she was a young ACLU staff lawyer. This is how she began her towering legal career. And in that capacity, she personally defended free speech for Alabama Governor George Wallace, remember, white supremacist. She personally defended free speech for other white supremacists successfully, and to this day continues to be very proud of that, being absolutely convinced that those victories enabled her colleagues in the civil rights movement to raise their voices with what was seen as being hate speech in many parts of the country.
Speak to the conflation of criticism of Israel with anti-Semitism and how this is used in the context of Jewish students feeling unsafe on campus.
This is a problem that goes beyond Israel. We've seen it a lot with China as well, where criticism of the policies of a particular government are somehow misperceived as not only criticism of people who live under that government, who share an ethnicity with the people who live there, but worse yet, is seen as being hate speech that should be suppressed. So let me, before we get to Israel, I want to say during the COVID crisis, when there was a lot of hate speech and discrimination, including discriminatory violence against Chinese people, Chinese Americans, and other Asians that got a lot of publicity, FIRE had to deal with situations on campus where students who were criticizing certain anti-human rights policies of the Chinese government, such as its oppression of the Uyghur people, were punished under campus hate speech codes for allegedly engaging in racist expression against Chinese people. So I hope that all of us here can make a distinction between criticizing the people and criticizing the policies. Now, where this comes to roost right now with the post-October 7th proliferation of pro-Palestinian protests on campus, too many campuses under pressure from both the Biden and the Trump administrations have been cracking down on not only violence and discriminatory conduct and unprotected speech, such as threats and bullying against Jewish students, but have also been suppressing, or in the case of the government, pressuring the universities to suppress either anti-Semitic speech or speech that's perceived as anti-Semitic or speech that is criticizing policies of the Israeli government. Now, I can't tell you how often people have asked me my opinion. Is from the river to the sea, is that anti-Semitic? Is it advocacy of genocide? I hope you now know from the first part of our lovely time together that from a First Amendment perspective, the answers to those questions are irrelevant. You have a right to express an anti-Semitic view, and other people have the right to react to it the way we have a right to react to any other discriminatory view, which will depend upon the circumstances, what we consider the most strategic, effective response to be, which could range from ignoring it, not giving it the platform that it's and attention that it's seeking, to engaging with it and trying to redeem people from their discriminatory ideas and so forth. But unfortunately, what we're seeing, and again, I think a lot of people don't know that this began under the Biden administration, so this is a bipartisan problem. Both administrations have been over-enforcing an anti-discrimination civil rights law, Title VI of the 1964 Civil Rights Statute, that prohibits any federally funded institution from engaging in discrimination on the basis of race, national origin, or color, and that has been interpreted to apply to Jews and Muslims, among others. And the Trump administration, but preceded by the Biden administration, have put pressure on campuses to crack down on not only discriminatory violence, not only discriminatory bullying and threats against Jewish students or Palestinian students and so forth, but mere expressions of ideas, usually ideas about government policy, what policy should be in the Middle East. And that, I think, is doubly dangerous, doubly defective, as all censorship is. Not only are you violating free speech, but I think you are thwarting an essential step toward bringing about further understanding in this country and around the world about these very complex, very important issues. We simply have to have people get beyond their silos of shouting warring slogans at each other and engage in difficult, deep discussions about the background and engaging with different perspectives.
Schools and universities have a high percentage of their professors and teachers who are left-leaning, Democratic, and who do not invite opposing viewpoints, but instead condemn them, and hence free speech. What has happened to critical thinking and discourse, the very purpose of education and democracy?
So there have been many studies that have verified the factual allegation here that not only students, but also faculty members, and even more so administrators are heavily tilted toward the left. And there also was a recent study that came out of Claremont McKenna College that looked at curricula around the country that concluded that the curricular materials are also tilted very much toward the left. Now, I think that is challenging to the critical inquiry and discourse that is essential as a method for approaching truth the goal of, which should be the goal of our educational institutions. And let me say that I mentioned earlier that a number of new organizations have been founded recently to address these problems, one of which is Heterodox Academy, which was founded about 10 years ago. One of the principal founders' name may be known to you, Jonathan Haidt, a very prominent social psychologist who teaches at NYU. And the reason that Jonathan founded Heterodox Academy, which very much supports academic freedom and free speech, was not specifically to promote academic freedom and free speech, but rather to enhance the effective search for truth through teaching and research and scholarship at universities. He and other social scientists had done studies that showed that because of the absence of viewpoint diversity, the homogeneity of perspectives on the part of faculty members, they were not doing as good a job, as effective a job in reviewing each other's research and subjecting it to constructive but tough criticism, and therefore the quality of the research and the scholarship and the education and the teaching was being undermined. So I do think that as truth-seeking institutions having that responsibility and special role in our society, we need to have more viewpoint diversity. And let me just say another organization that has been doing fantastic work in this area is the Mill Institute, named after one of my great heroes, John Stuart Mill, who to this day, I think, wrote the most powerful explanation and defense of robust freedom of speech, saying that every single idea, even those, indeed especially those that you hold most dear, must be subject to debate and to criticism and to questioning. There are only three possible outcomes of that process. Number one, if you may discover that your idea is wrong, and don't you want to be enlightened about that, to go back to our earlier conversation with Mark. Number two, you may find that, well, your idea was mostly right, but it could be refined and improved. Isn't that a benefit? And number three, even if as a result of the re-examination and debate and criticism and questioning, you land on exactly the same idea that you started with, you will understand it more deeply. You will be able to explain and advocate it more persuasively as a living, breathing idea rather than a dead dogma. So I'd like to send a special salute to the Mill Institute and my friend Eli Avishai, who I believe is here, who is the head of it.
Why can Trump defame Obama, saying he is a traitor with impunity?
Well, it's not impunity in the sense that short of government punishment or civil law sanctions and damages, you can suffer a lot through criticism. That's what the whole point of cancel culture is. And the ultimate punishment for something that Trump does that people dislike is to that he wouldn't be elected, or his party wouldn't be reelected, or his policies would be rejected. But the particular type of statement, can you tell me what this exact statement was again, Pete? It seems to me to be political hyperbole, but I want to hear it.
Yeah, that Trump says that Obama is a traitor.
Yeah, so first of all, to be actionable, and this would not be actionable defamation, no matter who said it. So don't think that because it's Trump, he has impunity. If Pete said that, or if I said that, or if any one of you said it, it also would not be actionable in defamation, not even because of First Amendment principles, but just because of the tort law principles of defamation. The first element of which is that it has to be an assertion of fact that is understood, that is intended by the speaker and understood by the audience to be making a factual misstatement, a lie. I don't think that that statement is reasonably perceived as even possibly conveying a fact. I mean, to be convicted of treason under the Constitution, it's spelled out in the Constitution. It's a very tough standard. It requires witnesses, and I think this is just a figure of speech. It's rhetorical hyperbole. And I know a lot of you don't like the fact that that was said. You wish that he hadn't said it. But let me give you an example that you might find, if not more congenial, at least coming from a very different political perspective, where the United States Supreme Court did not allow any kind of punishment of speech. It came from the Vietnam era, again, going back to my high school and college days, and there was a rally in Washington, D.C. against police brutality and unjustified killings of young black men. Sound like a familiar issue. It went all the way back to the 60s. And at that time, we had a military draft, and the client in the case was a young black man who was feared that he was going to be drafted. And he said, if they ever draft me and give me a gun, the first man I'm going to get in my sights is LBJ, referring to the president. And he was actually convicted for not only defamation, but also for threatening the president. And the Supreme Court, with respect to both allegations, said, you know, this is not taken, should not be taken literally. It's the kind of rhetorical hyperbole that in the kind of vigorous, vibrant, robust discourse we should have and encourage about political issues, people are going to have strong feelings. They're going to make intemperate statements. And, you know, you answer in the back, you ignore them, but you don't punish them.
While we were still on the Trump, what do you think of Trump's focus on universities and forcing them to making them changing hiring and admissions policies?
The devil is in the details, and to the extent that it's almost impossible to keep track of all of the executive orders and all of the executive actions. But to the best of and I actually subscribe to, there are now several Substacks that are called Executive Watch, and people full-time trying to monitor. So of the ones that I've been aware of, there are some that are consistent with the law to the extent that the focus is on ensuring that colleges and universities adhere to the Supreme Court decision in Students for Fair Admissions against Harvard, which, as you all know, held that any race-based, identity-based so-called affirmative action program, taking those criteria into account for admissions purposes, is now unconstitutional, violating the Equal Protection Clause. So to the extent that Trump is trying to ensure that universities actually adhere to that decision and do not try to do an end run around it through alternative mechanisms, that is permissible. But to the extent that there are other purposes and other impacts of the executive actions, that would be problematic. So searching back through my memory, I believe that some of the demands that were made of both Harvard and Columbia, and in Columbia's case resulting in a settlement, I do think that the administration was at least seeking even further authority, including complete access to all the data and information about the admissions process. And I believe that you can correct me if I'm wrong, there's so much going on, I can't swear that I'm remembering it all, but I believe that not only Columbia, but I read as recently as yesterday that Brown University has now also agreed to make all of that admissions data open to the administration. That leaves open the possibility of pouring over it for some other purpose, like maybe trying to see that more conservatives are admitted. Going back to an earlier question, there is a viewpoint diversity problem, but you don't solve it by discriminating on the basis of ideology in your admissions decisions. So again, the devil's in the details. We'll have to see how that massive new power is actually used. In one of the Supreme Court's leading cases on academic freedom, it defined academic freedom, interestingly enough, in an opinion by Justice Felix Frankfurter, who had been a very distinguished professor at Harvard Law School before he joined the Supreme Court. So he knew of what he was speaking. And he said that academic freedom includes the freedom to decide what to teach, how to teach it, who shall teach it, and who shall be admitted. So in other words, the institutional autonomy dimension of academic freedom does include autonomy over who is hired and who is admitted.
The First Amendment states that the government cannot suppress speech. While we may not approve of private institutions limiting speech, do they not still have the right to do so within their own boundaries?
Excellent point, and thank whoever asked it, because it's so fundamental. I'm embarrassed that it didn't come out in our opening remarks. Most people are not aware of the basic fact that the First Amendment, with its free speech clause, is only a restraint on government. It says Congress shall make no law abridging the freedom of speech. And while the word Congress has been interpreted unanimously by the Supreme Court to mean more than just the legislative branch of the federal government, it's been interpreted to mean all government officials and agencies at every level of government, state, local, and national. It does not extend to the private sector. So you have no First Amendment free speech rights against Dartmouth University, if you're Dartmouth College, if you're a faculty member or a student there. Notwithstanding that, virtually all private educational institutions, certainly including Dartmouth and Harvard and Columbia and all of the ones that have been in the news, have voluntarily adopted their own free speech policies that essentially track the same First Amendment principles that they would be required to adhere to if they were public universities. I think many people have heard of the famous Chicago free speech principles that were adopted by the University of Chicago in 2015 and have been spread all across the country at hundreds of campuses. The University of Chicago is a private sector institution, and yet it has prided itself since its founding in the 19th century that it is going to be devoted to academic freedom and free speech. Let me give a shout out to Dartmouth, because under the leadership of your impressive, relatively new president, whom I had the honor of doing a public interview of a couple of months ago, she really made it a priority, very clearly announced in her inaugural address, to protect free speech and academic freedom. She worked very closely with FIRE to earn the green light rating. I know the color green is Dartmouth's color, but in this context, it means that it is one of the pathetically small number of campuses in this country that have pro-free speech policies, and no policies that clearly violate free speech, no policies that are ambiguous with respect to free speech.
Since colleges and universities have no right to any government funding, doesn't the federal government have complete discretion to deny or withhold funding from any such institution?
These are such great questions, thank you. And it's a little bit analogous to what I said about library books, right? No book has the right to be in a library, but if the reason for removing the book, the purpose for removing the book, is viewpoint discriminatory, that does create a First Amendment problem. Same thing here. No institution has a right to government funding, but if the reason that government withholds or withdraws the funding is to punish somebody for exercising what would be a free speech right, that is equally unconstitutional. One way of thinking about it is this, that just as government may not use the stick of direct regulation to suppress certain viewpoints, it also may not use the carrot of funding to suppress certain viewpoints. And these principles were established in a number of cases. You may remember going back, I think, to the 90s, there were a lot of attacks on the National Endowment for the Arts over Robert Mapplethorpe's photographs and some other art that was considered to be, pro-feminist, pro-LGBTQ. And the ACLU represented the so-called NEA4 artist. Karen Finley, I think, was the named plaintiff. They were all projecting themes of feminism or LGBTQ sexuality. And the Supreme Court agreed with us that if the reason that they had no right to funding in the first place, and if the reason that they didn't get funding was because they were deemed not to have sufficient artistic merit, for example, that would be okay. But if the reason is dislike of the viewpoints they're conveying, that violates the First Amendment. And that's what we're seeing in many of the university situations now. Again, none of this has been fully litigated yet, so we have factual allegations, and the facts are very complicated, and there may be some viewpoint neutral justifications for some of the measures that are being taken, but overall there's a big concern that there's been a selective retaliation against schools for particular viewpoints, and sometimes it's very express. So we have a number of executive orders, I think I may have referred to this earlier, that specifically target not only the whole concept of DEI, but any course that refers to race or gender, or even that uses certain words.
How do you suggest we approach or engage with someone spewing hate speech?
Yeah, so that is a very strategic, first of all, thank you so much for the question, because I think doing something is really important. It's not an obligation, but I think especially those of us who are committed to doing something serious about and meaningful and effective about countering hatred and discrimination and and oppose censorship, really have a responsibility to raise our voices. And I would say there, you really have to make a determination in each specific situation what your goals are and what is going to be the most effective way to achieve those goals. Let me I've already given you examples of counter speech, the Daryl Davis example and the Megan Phelps-Roper example. Let me give you a very different approach, and I'm thinking to maybe about 5 years ago when there was there was a real pattern of white supremacist organizations recruiting on campus and having programs on campus, which prompted the Anti-Defamation League and the Southern Poverty Law Center, both of which are organizations that are committed to countering hatred and discrimination, so they're real experts. They put out a pamphlet that they distributed online to campuses around the country on what to do if white supremacists are coming to your campus. And they had a lot of positive suggestions, but the overriding suggestion was a negative one, what you should not do. And over and over and over again, the consistent theme was, do not try to deplatform them. Do not try to shout them down. Do not try to shut them down. We know that may feel very morally satisfying to you, but it's going to be counterproductive. It's going to give them the spotlight and the attention that they are hungering for. So the best thing you can do is to ignore them. And, and I saw some actual examples of, and the reason I saw it is because I follow this stuff. So I think many people see the publicity when a controversial speaker comes to campus and there's a violence or there's shout down or there's deplatforming. We hear about it, but you don't know when those very same speakers return to those very same campuses and maybe they get a pathetic little attendance, but there are no demonstrations, there's no news media there, and they don't accomplish their purpose, which is more attention and more recruits. So often the right to speak means exercising the right not to speak and ignoring. I would say in many situations, people are simply ignorant and recognize their ignorance and are hungering for information. We've seen this a lot on campuses in the wake of the terrorist attacks on October 7th, that there are a lot of students who really are very confused about what the history and recent politics and current politics are in Israel, Palestine, and really want to learn more about it. So anybody who can help, whether by providing information, by encouraging organizations such as your fine organization, or Dartmouth actually has gotten a lot of positive national publicity because it is one of the, sadly, few higher education institutions which early on and repeatedly has had respected experts from its faculty who have different perspectives and different backgrounds share their views and have public forums. That is an effective way of countering ignorance and the associated hatred and discrimination from either one of the too often binary warring perspectives.
Are public universities who fire faculty or staff for their hate speech violating the First Amendment?
It's a little bit complicated in this respect. If you're talking about class and somebody carrying out professional responsibilities as an educator, and if the hate speech is directed, I'm going to give you an example where clearly there should be punishment. A faculty member teaching a course says something hateful and discriminatory to a student or to a group of students in the class. That clearly is unprofessional, unprotected conduct, and should be subject to some kind of discipline, including potentially severe discipline. As an educator, I always like to begin with an educational approach and use a more harsh disciplinary approach only as a last resort. But I'm really not aware of even reports of that kind of situation. What we usually see, and the situations that lead to controversies and lawsuits, are when the faculty member is not acting in a professional capacity at all, but is speaking in a capacity as a citizen. This is the terminology that the Supreme Court uses. Extracurricular, a social media post, or attending a campus demonstration, or writing a letter to the editor. So let's start with this basic fact. Yes, it is true that if you are a faculty member, you may even speaking in your personal capacity, somehow have an adverse impact on the campus because you're associated with the campus and people will have a negative view if a faculty member says something hateful or discriminatory, even in their private capacity. And the same argument has been made about school teachers and firefighters and police officers, others who have public positions in the community. But the Supreme Court has rightly said, you should not give up your free speech rights as a citizen as the price of being a professor or a teacher or a firefighter or a police officer. So, you know, if Joe Q, Jane Q, member of the public, has the right standing on a, you know, a soapbox in a public park to say something hateful, then John or Jane Q public, who happens while on the job not to be able to say that, should have the right to say that off the job. And I think, you know, it's to me, I'll tell you candidly, where I think the hardest intersection of those two doctrines come, and I've had debates and discussions and dialogues with friends of mine in the academic freedom community, and we come out differently. Suppose a faculty member does say something hateful or discriminatory in his or her personal extracurricular capacity. Would a student justifiably feel that even if that faculty member did not voice those views in the classroom itself, that nonetheless they might feel that they might be subject to some kind of even unconscious bias by the faculty member? I think that's a very hard question.
Isn't the distinction between hate speech and physical violence or destruction of property just a matter of degree, without a distinction without a difference?
Excellent question, and in fact that essentially is question number one, or argument number one in the book that Greg and I just did. Very, very common and very important. And so this really comes back to those two cardinal principles that I talked about before. If it is simply violent rhetoric, so, you know, some people say from the river to the sea is conveying a violent, even genocidal idea, that's completely protected free speech. On the other hand, if the violent rhetoric in the overall context imminently threatens or directly causes certain specific harm beyond dislike of the idea, then it can be threatened, it can be punished. And I think one example is a threat, a true threat. If the speaker, and the Supreme Court has given a very specific definition, and it uses the term true threat, because in everyday English we tend to use the word threatening much more loosely. But to be punishable as a threat consistent with the First Amendment, the speaker has to intentionally or recklessly instill in a specifically targeted individual or small group of individuals a reasonable fear that they are going to be subject to violence. And so you understand that, and the speaker doesn't have to intend to actually carry out the violence because the harm is already done. If you reasonably fear that you're going to be subject to the violence, that chills your free speech and your freedom of movement. Another example, which I think I may have already alluded to as well, where there's enough of a connection between the imminent or direct violence and the speech in the overall context, is intentional incitement of imminent violence, where the violence is likely to happen imminently. And I know I saw at least 2 or 3 questions that specifically asked, what about Donald Trump on January 6th? And a very interesting example where so far different judges have ruled differently. It's a very fact-specific, factually intense inquiry. Under all of the facts and circumstances, looking at not only what Trump said then, but what all of the surrounding circumstances were. In fact, the judges have looked not only at all of the circumstances immediately before the speech on January 6th, but everything leading up to it, including election denial and disinformation and so forth. But here is the question that the finder of fact, whether a judge or a jury, would ask. In light of all of those circumstances, is there enough evidence that Trump intentionally incited, and by the way, the word incited is a legal term of art. The Supreme Court has literally said mere advocacy of violence is protected. It has to escalate from advocacy to incitement, and it has to be imminent incitement of violence that is likely to happen imminently. And to the best, last time I followed this, there were 2 different court rulings, and they had come out differently. In the 2016 campaign, Trump was actually sued for, on a similar theory, in a case arising, I'm sorry, somewhere in the Midwest. I'm from the Midwest, so I think I'm sorry, maybe Missouri, I can't remember. And he was holding a rally, and there was a counter-protester who had some anti-Trump sign, and the counter-protester had no right to be there. It was a pro-Trump rally. So that person could be escorted out lawfully, but the claim was that some Trump supporters roughed up and assaulted and injured the counter-protester, and the complaint was that Trump had intentionally incited the roughing up and the assault. Obviously, the assaulters themselves are culpable, as the January 6th criminals, those who engaged in violence and trespass, are punishable. The question is, can Trump also be punished? And in that case, the final decision was made by a judge, an appellate judge, who said, well, there was a lot that weighed in favor of finding that Trump was culpable. I think he said something like, get him out of here, and, we'll pay for your lawyers. It's very incendiary statements. But then the judge said, but on balance, at the end, Trump said, but don't hurt him. And I think that he was probably legally advised, because I've read over the transcript of January 6th many times, and there is a lot of incendiary, inflammatory language. There's a lot of other contextual background that would weigh in favor of finding him culpable. But the very last thing he says is go in peace, right? So I think he is following that Sixth Circuit precedent and just going as close to the edge as he can without going over it.
Okay, I think this will be the last question. How has the rise of social media impacted the cause of free speech?
The same way that all media have impacted free speech. Every medium is just that. It is a means, a conveyor belt for the content that we human beings, with all our positives and negatives, use it for. And therefore, it can do great harm, and it also can do great good. My perspective is that people tend to focus on the negative and take for granted the positive. And this is not true only for social media. For the old print media, there was a long cliche, not only print, but broadcast: if it bleeds, it leads, right? So we tend to emphasize the negative, and I defend the free speech right to do that. And I just want to say, from my perspective of not taking it for granted as a human rights advocate, there are so many extraordinary positives of social media, including positive movements for human rights and equal justice that many of us tried for decades to get off the ground, but did not get traction until we had the power of social media to make these messages go viral. The ACLU, starting at no later than the 1970s, had a campaign against disproportionate police violence and even killing of unarmed black men. And it really got nowhere until the Black Lives Matter movement, which had existed for a while, but taking advantage of social media's enormous power, catapulted that into the mass worldwide movement that had a lot of positive impact. Likewise, with respect to the movement against sexual assault and sexual harassment, I remember working on those issues before the Supreme Court even recognized such a concept back in the 1970s. And again, it didn't really get traction until the Me Too movement took advantage of social media to distribute, to amplify that message. So, and with respect to disinformation and misinformation and polarization, and including about debates about the Middle East, there are some really clever, creative, inspiring social media type tools, other online tools that are being developed by faculty members all over the country. Heterodox Academy is harnessing and distributing some of them that use algorithms, right? A lot of people are afraid of algorithms, that have used algorithms to help on an individual level people who have very different views about these controversial issues to engage in an informed and respectful, albeit very a strong disagreement, but in a constructive way. So I would say, let's emphasize the positive, let's maximize it. It is a more speech vehicle to bring about whatever positive goals all of us are striving for. And in this special audience, I know one value that we all very, very strongly share is lifelong learning and the joy of lifelong learning. We can and should use all of these tools to promote those incredibly important goals. Thank you.
Thank you so much, Nadine. It was a very enlightening presentation. And Mark, wherever you are, thank you too. See you next week.